the Data Protection Act, and the General Data Protection Regulation are laws that govern the way personal data should be collected, processed, and stored, with the aim of protecting people's privacy. In this lesson, you'll learn exactly what is meant by personal data. You'll learn about the key principles of these laws and the price to be paid for breaking them. You'll also learn about your rights if someone else is storing and processing data about you. First, though, let's consider how these laws came about. The original Data Protection Act was a British law that came into force as long ago as 1984. Along with the Access to Personal Files Act of 1987, it established some basic rules for the protection of data about people, data stored in paper-based filing systems and on computers. But advances in technology and changes in the way computers were used soon made these laws unfit for purpose. Following a directive from the European Union, the Data Protection Act of 1984 was replaced in 1998 with an updated version of the same act. At the time, the United Kingdom was a member of the European Union. This Data Protection Act of 1998 was much more detailed and much more concerned with the way that personal data were processed on computers. 4 years later, in 2002, the Data Protection Act was supplemented with the Privacy and Electronic Communications Regulation, another European directive. The PECR was also known as the E-Privacy Directive, or EPD for short. This law established even more controls, with a particular focus on electronic marketing methods such as email and cold calling. It also stipulated that a website should gain consent from a visitor before placing non-essential cookies on their computer. It quickly became known as the cookie law. Together, these laws served their purpose well for a number of years, but again was soon overtaken by technology. In May 2018, the European Union enacted a new law that would apply to all member states of the European Union, the so-called General Data Protection Regulation, or GDPR for short. Some sections of the GDPR were left open to interpretation, allowing different countries freedom to implement them in ways that best suited their own needs. So, in 2018, the UK enacted a new version of the Data Protection Act, whose purpose was to supplement the GDPR. The Data Protection Act of 2018 is therefore the United Kingdom's implementation of the GDPR. In the meantime, the PECR has been updated several times. The UK formally left the European Union in 2020 under the premiership of Boris Johnson. But, following so-called Brexit, the UK government decided to keep the GDPR in place with a few changes. References to the European Parliament and the European Council were removed, and any mentions of the Surveillance Authority were replaced with the Information Commissioner's Office. More about the Information Commissioner later. Other differences included the age at which a child is able to consent to the processing of their own personal data. In the European Union, the age is 16. In the UK, a child can give consent to process their personal data at the age of 13. There are also different rules for the way data about criminals should be handled, and for how data may be used for automated decision-making. Since January 2021, the GDPR has therefore been referred to as the UK GDPR. This all means that there is now more than one data protection law an organization must abide by, depending on who they do business with. If they process the personal data of United Kingdom residents, an organization must comply with the UK GDPR, along with the Data Protection Act of 2018. If they process the personal data of European Union residents, an organization must comply with the EU GDPR. Complicated? Well, it can be if you're a lawyer or a judge. But if you run a business or you're an individual that works with personal data, what really matters is what you need to do to stay within the law. And if someone else is working with data about you, then you should probably make it your business to know your rights. So, what exactly is personal data? According to the law, personal data means any information relating to an identified or identifiable living individual. This means pretty much anything about a living person that could be used to help identify them. Their name, address, telephone number, an email address, bank account number, national insurance number, student ID, the membership number on a library card, or a gym membership ID. But it doesn't stop there. Data is considered personal if it can be used to identify a person when pieced together with other data. For example, the IP address of a computer, or a username for a website. It can also include data that can confirm someone's physical presence somewhere, such as fingerprints, CCTV footage, or a GPS location. If a CCTV operator is tracking someone on the basis of their physical presence, but they don't know the name of that person, they are nevertheless processing personal data. There are even stronger legal protections for the type of personal data that might be used to unfairly discriminate against someone. So-called sensitive personal data, also known as special category data. Sensitive personal data includes data about race, ethnic background, religion, culture, sex life, and sexual orientation, political views, and trade union membership. It includes health data, such as medical diagnoses, medical history, disabilities, and data collected by fitness apps. Biometric data are also classed as sensitive if they're used for identification. Biometric data include the measurements used by face recognition applications, voice control, fingerprints, iris and retina scans, the shape of someone's ears, and even the way they walk. And these days, genetic information, such as the results of analyzing someone's DNA, are in the special category. Any organization that wants to process special category data must show that they have a very good reason to do so. For example, to protect public health or to carry out important scientific research. Or they must have explicit permission from anyone these data are about. A business, indeed any organization that collects and processes personal data, a so-called data controller, must abide by 7 key principles. The first of these is that personal data must be processed lawfully, fairly, and transparently. This means that a data controller must have at least one good reason for working with personal data in the eyes of the law, a so-called legal basis. One possible legal basis is consent, namely the agreement of the person that the data are about, the so-called data subject. Another legal basis is that the data subject might have entered into a contract with a data controller, and that contract requires them to reveal some of their personal data. An employment contract, for example, or a contract with an electricity supplier, or a club like a gym. You should bear in mind that many organizations will only provide you with online services, such as free email or a free social media account, if you agree to their terms and conditions. When you sign up for these services, you're entering into a contract, and very often, your personal data is the price to pay. A legal obligation is also a basis for the collection and processing of personal data. For example, a builder is obliged to keep records of the jobs he's done and the customers he did them for, in case the taxman wants to see them. Vital interests is another legal basis. This refers to matters of life and death. For example, a doctor's surgery works with patient data which might need to be accessed in the event of a medical emergency. Personal data can also be collected and processed in the public interest. The police, for example, can collect and process personal data in order to prevent or investigate a crime. Only public organizations such as law enforcement, local authorities, and government can use public interest as a legal basis. A commercial organization can't. Legitimate interests is the final basis for processing personal data. What this means is that it's okay to collect and process someone's data if it would normally be considered reasonable to do so, and if doing so doesn't threaten their privacy. This is somewhat vague, so as you can imagine, this legal basis is open to interpretation. One example is an employer collecting data about how well an employee is performing at work. Another example is that a business might collect data about people's spending habits, so these data can be used for marketing and advertising purposes. I'll come back to this example later when I talk about the data subject's rights. Whichever of these legal bases is declared by a data controller, they are normally required to be completely transparent about what they do with the data. In other words, the data subject should be made fully aware of how their data are being collected and used. Furthermore, any communication about this from the data controller to the data subject should be in plain, simple language and easy for them to understand. The requirement for transparency brings us on to the second key principle. That is, personal data must be used for specified, explicit purposes. In other words, the data controller can only use personal data in a way they said they would in the first place. A data controller can't use a data subject's data to try and sell them something unless they made it perfectly clear that they were going to do so before the data were collected. Personal data sharing between data controllers can have some real social and economic benefits for a data controller and their data subjects. So a data controller is allowed to share or even sell the personal data that they control without the data subject's explicit consent. However, a data controller is not allowed to share or sell personal data unless they made a few things very clear to the data subject in advance. Namely, with whom the data will be shared, the purpose of sharing, the legal basis for sharing, and a mechanism by which the data subject can opt out. A checkbox or a link on a web page perhaps. Of course, when personal data are passed on like this, new data controllers become involved, and they too must abide by the 7 key principles. There have been a number of high-profile cases in which the data controller has not made clear their intentions to share personal data. Facebook, who now call themselves Meta, gave away the personal data of over 87 million Facebook users to an organization called Cambridge Analytica. These data were used for political advertising in the United States of America without the knowledge of the data subjects. This no doubt had a massive impact on the 2016 presidential election results. Facebook were consequently fined a record-breaking $5 billion by the Federal Trade Commission. Cambridge Analytica filed for bankruptcy, and you probably know the rest. The third key principle states that personal data must be adequate, relevant, and limited to only what is necessary. In other words, a data controller can only collect the minimum amount of data required to fulfill their needs. For example, a restaurant might collect the contact details of its customers so it can tell them about any special offers coming up. But they don't need a customer's employment history to do this. On the other hand, a school, a college, or a university can legitimately collect vast amounts of data about students, including names, addresses, qualifications, attendance data, achievements, exam results, behavior records, medical information, and more. The fourth key principle requires that personal data must be accurate and, where necessary, kept up to date. A data controller must take reasonable steps to ensure that any personal data found to be inaccurate are corrected or deleted without delay. Of course, this puts some responsibility on the data subject too. For example, if someone gets married or moves house, the onus is on them to tell their employer or their bank. Principle 5 states that personal data must be kept for no longer than is necessary. In order to ensure that this is the case, a data controller should establish time limits for the storage of personal data, or at least periodically review whether or not the data is still needed. Principle 6 states that personal data must be kept secure. If it's on paper, it should be locked away. If it's on a computer or a portable backup medium like a memory stick or a DVD, it should be encrypted. Anyone that handles personal data as part of their job is a data processor and has a legal obligation to keep it secure. For example, a school employs teachers who work with personal data about their students on a daily basis, some of it very sensitive. If a teacher allows personal data about one student to be seen by another without the data subject's permission, they are breaking the law. The leaders of any data controlling organization have a duty to ensure that their employees know how to handle personal data properly, and that employees know that they are personally liable if they don't. The seventh and final key principle requires that any data controller must be accountable for what they do with personal data. That is, they must be able to demonstrate that they have complied with the other principles. This means that they need to have policies and procedures in place to allow for the correct handling of personal data. And they must keep detailed records as evidence of these procedures and policies being followed. It's also good practice for a data controller to provide training for its employees so that individuals don't fall foul of the law. In addition, data controllers are responsible for ensuring that any third parties that process personal data on their behalf also comply with the law. For example, a gym might pass personal data to a printing company so they can print invitations to a special event that they're holding. Or a school might use an online virtual classroom hosted by a completely different organization that specializes in providing that kind of service. Here's a summary of the 7 data protection principles. It's reasonable to suppose that dozens, if not hundreds, of different organizations store and process a vast amount of data about you. As a data subject, the Data Protection Act and the GDPR give you a number of legally enforceable rights. For a start, you have the right to be informed exactly how your personal data are being used. If you sign up for an online service which collects personal data of any kind, the operator of that website is necessarily a data controller. Even if you simply visit a website or a search engine and all they do is record your computer's unique IP address, don't forget every computer connected to the internet has one, then that website operator is a data controller. These website operators have a legal obligation to publish a privacy policy, a document that explains exactly how they collect, handle, and process the data of their customers and visitors. A privacy policy also explicitly states whether your information will be kept confidential, or if it might be shared with or sold to other organizations. But it's not just website operators that must have a privacy policy. If you apply for a job or enroll on a course, for example, anyone who collects your personal data, even if it's on paper, must be able to show you their privacy policy. You have the right of access. In other words, you have the right to receive a copy of the personal data that an organization holds about you. You can ask for this in writing or via social media. This is called a subject access request. Normally, you must be provided with a copy of your data within a month, and it should be free of charge. The information given to you should also be in a form that's easy for you to access and easy to understand. If the data are particularly complex, an organization might take up to 3 months to fulfill a request, and they can charge a small administration fee, but they must respond within a month and explain why. Most organizations have an appointed data protection officer, DPO, whose job it is to ensure that they comply with the law and deal with any subject access requests. You have a right to rectification. If your personal data are found to contain mistakes, you can insist that they are corrected. You also have the right to have your personal data permanently deleted. For example, you might have joined a club and given consent for them to process your personal data. If you leave the club, you can withdraw your consent and insist that your personal data are deleted within a month. Or perhaps you have a social media account containing lots of posts and images that you want to get rid of altogether. You can ask for your data to be deleted within a month of closing your account. This legal right is often referred to as the right to be forgotten. Certain types of data controller can legitimately refuse to delete your data. The police, for example. Reasons for refusal could include that your data are being processed in the public interest or for public health reasons, or if they're needed to investigate a crime. You have the right to stop your personal data from being processed or limit the way in which they are processed without being deleted. Perhaps you're waiting for incorrect data to be put right. You can therefore insist that your personal data are not used in the meantime. In another scenario, perhaps you're in a legal dispute with an employer. You can insist that your data are kept for evidence, but not used in any other way. As with a request to delete data, certain types of data controller can refuse a request to stop processing for the same reasons: public interests, vital interests, and so on. The right to data portability is the right to receive a copy of your personal data in a structured, commonly used, computer-readable format, so that you can pass it on to another data controller. You also have the right to request that a data controller transmits your data directly to another data controller's computer system. This means that a data controller needs to be able to provide any electronic data that they have about you in an open format, such as CSV, XML, or JSON. Having the right to portable data means that you can easily change from one bank to another, or from one utility provider to another. You can also take advantage of applications and online services that might use your data to find you a better deal when you're shopping for goods and services. It should be said, however, that this right only includes raw data that you gave to a data controller. For example, your name, address, date of birth, and so on. Raw data also includes anything they collected by watching you, like your emails, social media posts, your internet search history, location data collected from wearable devices like smartwatches, and so on. What your data controller is not obliged to pass on is any additional information that they inferred from what you gave them. For example, a data controller might draw conclusions about you, such as what you like and don't like, and therefore what you might spend money on. Nevertheless, you can still make a subject access request under your right to be informed in order to see everything they think they know about you. The Data Transfer Project is worth a brief mention at this point. It was founded in 2018 by Google, Microsoft, Twitter, SmartMug, and Facebook, who now call themselves Meta. Apple joined soon after. Their objective was to create an open-source system that would make it easy for individuals to move their personal data from one online service provider to another whenever they wanted. Data such as social media posts, photos, videos, music playlists, email contacts, and the like. As more and more companies get involved, the Data Transfer Project promises to create new opportunities for businesses and to empower customers to try new things and find exactly the right services to suit their needs. On the other hand, it could put someone's personal data at greater risk of abuse. It remains to be seen. It's quite common these days for vast amounts of personal data to be processed by artificial intelligence. Various aspects of people's personalities are analyzed, like their interests, attitudes, and the way they behave. This type of analysis is called profiling. An individual's profile information can then be used to make predictions and decisions about them. Banks and insurance companies often use this type of information to decide whether or not to give someone a loan, a mortgage to buy a house, or insurance for their car. Under the GDPR, you have the right not to be subject to any decision made by purely automated means, that is, without any human involvement. You also have the right not to be subject to automated profiling. A data controller is only allowed to carry out automated decision-making if they have your explicit consent, if it's necessary to fulfill a contract with you, or if it's been authorized by a law enforcement agency. If the data controller is using sensitive personal data, they must have your explicit consent, or it must be for reasons of a substantial public interest, such as the prevention of a crime or a terrorist act. Although it's not mandatory, it's considered good practice for a data controller to tell you the details of any profiling or automated decision-making that they do, including where the data comes from. However, they absolutely must explain to you how you can access details of the information used to create your profile, and they must have simple ways for you to request human intervention or to challenge an automated decision. Last but not least, you have the right to object to how your data are being processed in some circumstances. As you've seen, one of the key principles of data protection law is that an organization must have a legal basis for collecting and processing personal data. And one possible basis is legitimate interests. This includes targeted advertising and marketing. However, you have an absolute right to object to your personal data being used for direct marketing. A data controller cannot refuse a request to stop doing it. You can also object to your personal data being used for scientific or historical research, or for statistical purposes, unless this type of processing is being done in the public interest, to develop a new vaccine, for example. Here's a summary of a data subject's rights. There are a few notable exceptions to the Data Protection Act and the GDPR. Domestic data, that is, personal data which you store for household purposes, fall outside the scope of data protection laws. You might, for example, store the names and addresses of your loved ones, so you can send them birthday cards from time to time. Or you might keep digital images of your friends and family on a smartphone, simply for your own enjoyment. As long as the data have no professional or commercial purpose, the data protection principles don't apply. Law enforcement agencies are subject to data protection laws, but they can deny someone access to their data if it's to protect the rights and freedoms of others, or if disclosure might obstruct the investigation of a crime. Access can also be denied by some other organizations. For example, in the United Kingdom, the Inland Revenue can withhold data if they're being used for the assessment and collection of tax. Intelligence services like MI5, MI6, and GCHQ can also withhold data in the name of national security. Furthermore, any organization that has the power to withhold information doesn't have to reveal why they're withholding it. In the United Kingdom, the Information Commissioner's Office, ICO for short, is ultimately responsible for ensuring that a data subject's rights are upheld and that any data controllers who fall foul of the data protection laws are held to account. In the European Union, the European Data Protection Supervisor has the same responsibility. Any breach of security leading to unlawful or accidental disclosure, loss, destruction, or alteration of personal data is a serious matter. If such a breach presents a risk to anyone's rights and freedoms, it must be reported to the Information Commissioner's Office within 72 hours. The data subjects involved should also be notified as soon as possible. If an organization fails to comply with any of the data protection principles, or if it fails to meet an individual's rights, the ICO will take action. This could be a simple warning or reprimand, or they might impose a temporary or even permanent ban on data processing. Potentially, however, the data controller could be facing a very large fine. Depending on the nature of the infringement and the number of people affected, a data controller operating in the United Kingdom could be fined up to £17.5 million, or 4% of their annual turnover, whichever is greater. If they operate in the European Union, they could be fined up to €20 million, or 4% of their global annual turnover, whichever is the greater. There are many high-profile examples of companies being fined for breaking data protection laws. In 2019, British Airways was fined £183 million because hackers were able to gain access to customers' names and addresses, travel booking information, and payment card details. In the same year, the Marriott hotel chain were fined £99 million for failing to protect the personal data of almost 500 million guests. Again, this was the result of a hacker attack due to weaknesses in the company's online security. In July 2021, Amazon was fined a massive €746 million for failing to comply with the rules relating to cookie data. WhatsApp was fined €225 million for leaving information out of its privacy notice. Unfortunately, this list continues to grow, and there's no shortage of repeat offenders. Finally, let's say something about personal data protection laws around the world. There's no single data protection or privacy law in the United States of America. Different states have their own laws. California's legislation is thought to be the most progressive, with the California Consumer Privacy Act, CCPA. This provides particularly robust consumer protection and privacy rights. The Federal Trade Commission Act is a country-wide law that can be used to prosecute an organization that doesn't follow its own published privacy promises, and if it fails to keep personal data safe. India has grown into the world's second largest internet market, and because of this, there's been an explosion of personal data in the past decade. India also has Aadhaar, the world's largest biometric identification system, with over 1 billion people able to access government services through it. In 2017, India's Supreme Court ruled that privacy is a fundamental right of all its citizens. Various laws include data protection requirements, such as the Information Technology Act, the Consumer Protection Act, the SPDI rules, that is, rules for protecting sensitive personal data or information. A new personal data protection bill was drawn up in 2019 to improve the rights of Indian citizens with regard to their personal data. It was intended to be similar to the European GDPR. But the bill gave government departments and several other national agencies the power to intercept, monitor, and decrypt digital information of any kind, including personal data. Critics of the bill, including many multinational technology companies and civil rights organizations, said that it put the interests of the government first without respecting people's constitutional rights to privacy. The bill was withdrawn in August 2022. Several other countries have recognized the importance of protecting personal data through legislation. Even China, a non-democratic country with a reputation for human rights abuses, has the Personal Information Protection Law. And Russia, controlled by a warmongering dictatorship, also has a law to monitor the use of personal data. Although the protection of citizens might not be at the center of this one.